get too heavily into these papers today. That is that the bundle has been supplemented many times since Mr. Natterson's last evidence, and so we go to points of points later on, but I hope to be able to navigate through that with everyone today. But we start at page 442.25, Chair, with the response that was received to the inquiries that the Commission's made after Ms. Tlatsana's evidence. And there are aspects of it, Chair, which are concerning and which we bring to your attention. What was asked was for an update on the case that she lodged, and what you see on page 442.25 is that the case was lodged with a warrant officer at the Mahikeng Detective Service on the 4th of January 2018. That was acknowledged. You'll find that in the second paragraph. And then in the penultimate paragraph, the author of this document, who is the Deputy Provincial Commissioner for Crime Detection in the Northwest, indicates that they made investigations, and upon perusing the docket, the officers were, and I'm quoting, in dismay to learn that there was nothing positive that the investigator did in the docket, and there was no command and control from the commander's side. In the last paragraph, it goes on to say the Provincial Office have since removed the state investigator from the investigation at the Mahikeng Detective to the Provincial Office, where the case is presently investigated by Provincial Organised Crime. And Chair, if you go over the page, there's also an indication that disciplinary investigation against the concerned members has been initiated. Chair, we give you that update because you specifically asked for it.
Yes,
It appears that no investigation whatever was done on it, and that was of concern certainly to the Provincial Commissioner.
Yes, and it's been more than a year and a half since the complaint was laid.
Chair, I can also indicate to you that the Commission's investigators are seeking to take aspects of that intimidation case forward in our own investigations.
Yes.
Because there is a possible link with other aspects of the evidence, and so they are seeking to work with the police in that regard.
Yes. No, thank you. Will you just make sure that Ms. Natterson is made aware of this response, and at some stage it would be good to hear how far the investigations are.
Indeed.
Yes, it doesn't have to be soon, but at some stage it would be helpful.
Chair, you indicated Ms. Natterson. I take it you meant Ms. Tlatsana.
Oh, no, I'm sorry. Hi.
Not at all.
Yes.
Thank you.
Yes.
Chair, on the topic of Ms. Tlatsana, though, there is a second update that I must bring to the Chair's attention today.
Yes.
At the conclusion of Ms. Tlatsana's evidence, she was requested to provide a further affidavit to the Commission in which she would account in full for the full 51 million rand that came into the account of Coroneka, the CC, which she was the member of. And so the Commission took steps after her evidence to follow up with her and to obtain that further affidavit. In the course of those engagements, the Commission interacted with her lawyer, Mr. Knight, who was present during her evidence. He has indicated that there were threats made and intimidation to Ms. Tlatsana after her evidence before the Commission, the consequence of which is that, in fear for her life, she has left the Republic. Chair, his affidavit setting that out, you will also find in Exhibit DD10B, and you'll pick it up at page 442.27.1, so it's just about 2 pages on from where we were.
Yes.
Chair, you'll see there that this is an affidavit deposed to by Julian Brett Knight, who is Ms. Tlatsana's legal representative. If you pick it up at paragraph 2, he indicates in that affidavit that he was advised by his client, that's Ms. Tlatsana, that out of fears for her safety after her testimony to this Commission, she decided to remove herself from the territorial limits of the Republic of South Africa, the precise destination whereof is unknown to him. He goes on to give the facts as they were relayed to him by Ms. Tlatsana. He says at paragraph 3, after having testified before the commission, Ms. Tlatsana advised that she observed suspicious activity around her residential property in Mahikeng, where unknown men who did not identify themselves approached family members inquiring about her whereabouts. And if you go over the page, he goes on and says, I'm instructed that an attempt was also made to gain entry to her residence. At paragraph 5, he records, as a consequence of feeling unsafe, Ms. Tlatsana decided to leave the Republic of South Africa. And at paragraph 6, he records that she's advised him that she appointed an auditor to write up the finances of Coroneka CC, which he understands is currently in progress. That's in direct response to the further information that she was required to provide to the Commission. Chair, when the Commission received this information, it took it very seriously. We have engaged our own investigators, particularly on aspects of security, and they are updating us regularly on this, as recently as yesterday. But as matters currently stand, it does appear that Ms. Tlatsana is not within the Republic. And as we have it from a lawyer, this is the explanation, at least, that she gave him for having left the Republic after her testimony.
This is quite concerning. Because the impression I have and my recollection of everything relating to this matter is not perfect, is that although she would have brought issues of her concerns in regard to safety and threats to the attention of the authorities, the authorities don't seem to have done anything.
Indeed.
And she had come and given evidence, and according to this affidavit, subsequently, it appeared that she was under threat, and she left. She didn't feel, it seems, protected or safe. Okay, I would like to be updated.
Indeed.
In regard to the matter. Okay.
Thank you, Chair.
Thank you.
Chair, if I may then suggest that we continue with Mr. Natterson's evidence. He was placed under oath on the last occasion.
Yes, maybe because of the lapse of time, we can do the oath again.
Please state your full names for the record.
Vivian Natterson?
Do you have any objection in making the prescribed affirmation?
No.
Do you solemnly affirm that the evidence you will give shall be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, I truly affirm.
I truly affirm.
Thank you.
Thank you, Chair. Mr. Natterson, I'd like to...
Which bundle will you be using most of the time?
We will start with A, Chair.
A,
DD10A.
Okay.
Chair, there will be a few other bundles. Predominantly, we will be using A and B today.
Okay.
There will be one or two other bundles we'll go to, but
Yes.
my arrangement with your registrar is he'll make those available to you as and when it's appropriate.
Okay, that's fine.
Thank you. Mr. Natterson, if we can commence in Exhibit DD10A, if we may. And I'd like to start at page 25 there. Now, 25 is a part of the statement that you provided to the Commission on the 3rd of May of this year. That was before a meeting you held with the Commission the following Monday on the 6th of May. And I'd like to pick it up at paragraph 13 on that page, because at paragraph 13 is where you deal with the 300,000 rand that was paid in cash to Mr. van Wyk. Chair, just to orientate ourselves, you might recall from the last evidence, there were a series of electronic transfers out of the Neo Solutions account to an account of Batsamai Investments. There were 4 in total. But the one outlier is a 300,000 Rand in cash that we hadn't got to in Mr. Natterson's evidence last time, and that's the topic I'd like to address with Mr. Natterson now.
Okay.
Mr. Natterson, this was the draft that you returned to the Commission on the 3rd of May. Do you recall that?
Yes.
It was signed by you. You can find that on the last page. Do you recall that?
Yes.
And that was a version of your statement that you had worked on previously to produce this document we see at this page. Do you recall that?
Yes.
So if we look at paragraph 13 on that page, could you indicate there what explanation you give about the 300,000 Rand that was paid to Mr. Van Wyk?
I had explained at the time that I had a portion of cash with me. I don't normally, obviously, have cash at home. Our business does not generate cash, so it's not out of the business proceeds. So I had explained at the time that I had disposed of a vehicle, one of my private vehicles, and the buyer had secured the vehicle by paying me a portion in cash.
And tell us how it came that Mr. Van Wyk wanted this 300,000 to be paid.
He requested it a portion in cash because I believe at the time he wanted to secure a vehicle, a classic car that he wanted to buy, and he asked for that portion in cash.
Okay, so if we could just unpack that a bit. When did this happen?
I can't recall exactly, but it was at the start of the year. He basically called me. I was out of town, and he called me and said he needed it, and then I had to obviously then make arrangements for my brother to retrieve it.
So that was early in 2016, is that correct?
That's correct.
Prior to the 4th of January 2016, correct?
Yes. Well, on or about that day.
It could have been the 4th itself,
Yeah.
could it? And explain to us the communication. How did it take place?
I assumed, well, look, he probably called me over WhatsApp. He used to call me over WhatsApp calls because he used to use data.
And what did he say precisely?
He first said he needed 300,000, and then I said, well, I could do the transfer or tell Eugene Rubin to do the transfer. Then he said, no, he needed it in cash. Then I said, okay, fine. I happen to have some, so I then arranged for him to get it.
And what reason did he give for needing those funds on the 4th of January 2016?
It was to purchase a vehicle, he said.
Did you make inquiries of him about why he needed it then?
I just knew that he collected cars, so, I mean, quite often I would also do it. If I buy a classic car, I would buy it. If it's a small number, I would generally pay cash because the sellers generally want cash.
And why facilitate this while you were still on holiday?
Well, he said he would lose the sale if he didn't do it then.
And why didn't you suggest to him that he'd just go to his bank and withdraw 300,000 Rand?
Well, he said that the bank, that he wanted cash, and I said, well, I happen to have it. It was just that I had it, and I wasn't going to use it for anything, so I gave it to him.
So you didn't see it as odd that he wouldn't want to go and get 300,000 Rand cash out of his own bank account?
I just understood it to be short notice that he needed to execute that sale quickly.
So he went to you rather than a bank?
Well, he asked me, and as I happened to have had it, then I gave it.
Did you follow up with him afterwards about whether he did purchase the car?
No, I was still on holiday. When I got back, I didn't think anything of it. I just obviously had told Eugene to make sure it comes off his, obviously off his loan or his account would be, into against my shareholder loan account.
So let's just explore that a little bit further. Your brother's affidavit before this commission indicates that you and Mr. Van Wyk held an interest in vintage cars. Is that correct?
No, we didn't have an interest in vintage cars. We had interest as in shareholding or interest?
No. You were.
We shared a passion
It's
about
a passion, right? That's probably a better word. A passion for vintage cars. Tell us a bit about that. How did that develop in your relationship?
At the start, when he used to attend functions, he mentioned that he used to collect classic Rolls Royces. He even showed me pictures at the time of some classic Rolls Royces that he had. He had mentioned, in fact, that's why that number resonated with me, was he had mentioned previously in the year that he was looking at buying another one, and the price range he spoke about was the 300,000. So it sort of resonated when he asked for 300 for the car.
So the whole car would cost 300,000?
Yeah, it's a 1984 car. thereabouts.
Oh, so it was a specific car, 1984 car.
When we spoke about cars, it was in that price range for that time of period of car. So a 1984 Rolls Royce would cost in the region of 300,000. He didn't have a specific car in mind then.
Did you ever look at each other's vintage cars, or?
I'd never seen his. He's never come to my home with one, but I've never seen it.
So
He knew that I had some as well. I had an Anglia and a Chevy.
So you never drove them together at any events?
Yeah.
And did he specifically mention the 1984 car again when he spoke to you in early 2016?
No.
Thank you. I'd then like to go to what you say further down at paragraph 13 on page 25. Because there you recount much of what you've said already, that you were out of town on that day, that you sent your brother to collect the money in the house and meet with the person sent by Mr. Van Wyk. And then you go on and say, Mr. Van Wyk called me later to confirm receipt. And you say you can confirm that your brother would confirm this if he was to be called. Of course, events have developed since then. Your brother gave an affidavit to the commission.
That's right.
Together with your affidavit on the 12th of July. Is that correct?
That's correct.
And then I'd like you please to read what follows thereafter from the sentence "at this stage."
At this stage, I had sold one of my cars, a 2009 DBS Aston Martin, and the buyer gave me some of the funds in cash. I sold the car for 1.4 million, and 300,000 was paid in cash, and the balance was paid to my account.
And then carry on.
That's the reason why I had cash on hand.
Thank you. Do you remember why that was added in your statement after the previous version that you'd worked on?
I can't recall why.
Do you recall a meeting in April with the Commission where they probed why there would be 300,000 rand lying
cash.
around at your house? And was this the explanation you gave them?
Yes, yes.
And then you had a meeting on the 6th of May with the Commission where this aspect was probed further with you. Is that correct?
Yes.
And do you recall being asked to provide your bank statements in order to get further support for the version that appears at paragraph 13?
Yes.
Do you recall having provided those bank statements?
I think they were being submitted.
And do you recall whether they reflected a payment around that time of 1.4 million into your account?
It wasn't reflected at that time. The buyer obviously secured the car with me, but he had a delay in terms of obviously securing his finance. So at the time when the finance went through, I think we submitted those documents through to you of the agreement of sale that happened later.
Is that
But that happened in 2017, I think. But you've got the documents.
We do. The document you submitted is a sale in September 2018. So can I just be clear? On the 4th of January 2016, you had 300,000 rand in cash at your house because of a sale of a car that only materialized in September 2018.
Yes, because the buyer, obviously, he was leaving his employment and he wanted to obviously secure the car. Well, he didn't at the time have the money to be able to secure finance, or he couldn't get finance for the car. So he asked me to obviously wait, and that's when we finalized the sale, was when he was able to do so.
2 years and 7 months later.
Well, look, he had paid, the car is a special car, it's a collector's item. So obviously he wanted to secure it. He paid me the 300 to secure it.
Mr. Natterson, do you know that your brother has a different account of why you had 300,000 rand in your house at the time?
No. What's his affidavit saying?
Let's go to it.
Has he not seen that affidavit before, Mr. Natterson?
Oh, he has. It's an affidavit he produced for the Commission.
He produced. Okay.
If you go in the same bundle to page 238.144. Well, let's just orientate ourselves. Let's go back 2 pages so that you'll see.
I'm sorry, 238.
238.142, Chair, is where I'd like to commence. I might have
In the
inverted
same
the numbers.
bundle, eh?
In the same bundle,
Two. I've got 238.1, 238.2.
apologies, Chair, you're going to have to go quite a bit further because it's a point after 238, but you've got to go all the way down to 238.142.
Okay.
Chair, I did give the apology at the outset for these
Yes.
dreadful numberings.
Is that the affidavit of Mr. Sherwin?
Correct.
Natterson?
Do you
Okay.
have that page, Mr.
Yes.
Natterson? Is Mr. Sherwin Natterson your brother?
Yes,
And this is an affidavit that you produced to the Commission.
Yes.
It was an annexure to the affidavit that you provided on the 12th of July, 2019, on the morning before you testified last time. Do you recall that?
yes,
If you go over to page 238.144,
yes,
you'll see at paragraph 9 at the top of the page, your brother says there, Mr. Natterson, with a reference to you, advised him that you had built up some cash from selling off some of his old cars, some parts and spares, and had scraped up the 300,000 to give to a person that Van Wyk had designated to collect from the office. Do you see that?
yes.
Do you see that that's different to the version you've just given?
His understanding was that I had sold an old car.
No, his understanding is that you had scraped together 300,000 by selling cars in plural, some parts, and spares. Do you see that?
Yes, but that's his understanding.
So,
I didn't specifically tell him I sold my Aston and I had a 300,000 deposit there. His understanding was it was from selling off my old cars.
but he says this is what you told him, correct?
Yeah, but that's his understanding. I didn't say that. I've said I sold a car. So that's how he understood it.
He understood I sold a car to mean you'd scraped together, pursuant to numerous car sales and sales of parts and spares, 300,000 rand. Is that your
That's his
testimony?
understanding of what he was told, but I said I'd sold my car.
So it's the specific Aston Martin, in respect of which ownership only passed in September 2018, that you say you got 300,000 rand for in cash in early 2016.
To secure the car. The buyer needed to secure the car because obviously he wanted it and he didn't want me to sell it elsewhere. And when he got the money, or the ability to finance it, he financed it.
Can you tell us who that purchaser was?
I can. I think it's in my affidavit.
It's not to my recollection.
Okay, his name is Gerald Strauss.
Strauss. So he paid you 300,000 rand in cash for a car in 2016, and you remained the owner of it for 2 years and 7 months, and then you got paid the balance.
Correct, yes.
And if we were to ask Mr. Strauss about that, would he confirm that?
You're welcome to ask him. We can provide the details.
Would he confirm it?
He will confirm it.
Well, I wasn't sure whether that question was fine, but you have answered whether or not he would confirm.
Well, that's up to him, but ultimately, I know what happened, what transpired. That's my version.
Yes, no, that's what I'm saying, that unless you have recently spoken to him and asked him whether if he's called you would confirm that, you wouldn't know
Okay, that's
whether he will confirm. All you would know is if, as far as you are concerned, if he tells the commission what happened, he should confirm. But
Fair comment,
I
Chair.
think we do understand. Ms. Hoffman.
Indeed. Thank you, Chair. Just one point of clarification. When was the cash given to you in relation to the car?
It was before I left on holiday.
So when was that?
It would have been during early December.
Of 2015. Why didn't you go and place it in the bank?
I was about to leave on my holiday, so I just kept it. And sometimes I might need it to buy another car or jewelry or watches or something, which I would pay cash for with it.
So do you generally keep quite a bit of cash available?
I had already testified that I don't.
So this was a rare occasion where
Correct.
you kept 300,000?
Correct.
And in December, it was your intention to keep it in cash in case you needed it for a purchase?
Correct.
Either of jewelry or cars, correct?
Correct.
Why did you then hand it over to Mr. Van Wyk on the 4th of January 2016 if your intention was to keep it for your own purchasing?
He asked for it, and I was going to take it off the monies that I was going to give back to him, or it was basically just an offset.
Thank you. I'd then like to go to your 12 July statement, and we can pick that up at page 238.66 in the same bundle, A.
238.
Chair.
Thank you. That's not where it starts, eh?
It doesn't start there, no, indeed, Chair. It
Yes.
starts a few pages back at 238.61.
Okay.
Mr. Natson, can you confirm this is the statement you provided to the Commission on the morning before you testified last time?
Yes.
And I'm picking it up at page 66, 238.66, because I'd like to look at paragraph 24 there, because this is the part of your 12 July statement in which you deal with the 300,000 rand. Do you see that?
That's right.
And there you say, similarly to the testimony you've given today, that during or about January 2016, Van Wyk requested that I release the amount of 300,000, being the transaction referred to above. That's where you'd itemized what payments were made. And you say in cash to him as a matter of urgency with the advices that he needed same for an urgent personal purchase. Do you see that?
Yes.
That's consistent with what you've told us this morning, correct?
Correct.
Can I just confirm, because it may be that Mr. Van Wyk comes to give evidence in due course before this commission, did he at any point in his conversation with you in early January 2016 refer to the ANC's annual celebrations and need for cash in relation to that?
No.
And did he make any reference to reflector jackets that were required for those celebrations and in respect of which he needed to pay 300,000 rand?
Definitely not to him.
Thank you. And Mr. Natterson, you then go on and you say, in the light of the fact that I was away at the time, I asked my brother Sherwin to attend at my house, open the safe, and to take the amount of 300,000 rand from my own personal funds in order to make payment to Mr. Van Wyk urgently, which Sherwin duly attended to. Do you see that?
Yes.
So, Mr. Natterson, it's clear, it seems to me from this, that it was your own personal funds, not the funds of Neo Solutions, that were being used to give to Mr. Van Wyk on the 4th of January, correct?
That's correct.
And then it would be fair, I suggest, unless you hold a different view, that it was you in your personal capacity, not Neo Solutions, the company, but you in your personal capacity who were now assisting Mr. Van Wyk to convert a portion of the monies that had come into Neo Solutions into cash for his own use. Is that correct?
Yes, it was personal.
What does that mean?
I said it's correct that you say that the funds were my personal funds. However, the transaction was processed where I took it off the monies that he had with us, and I put those funds, all that monies against my personal loan account to the company.
Can we look at that? Because you do pick it up at paragraph 25. At paragraph 25, you say there, in light of the fact that my own personal funds had been used in order to repay Van Wyk as mentioned in paragraph 24, same would have had to be repaid to me, from Van Wyk's funds that Neo Solution was possessed of in due course. Do you see that?
Yes.
Just like to explore that a little bit further. You say would have to be repaid. Were they repaid?
I deducted it from the amounts that he had with us.
Yes, but you say here, remember it's your own personal funds. So you had to be repaid. Were you repaid?
No, it's still sitting in my loan account with the company. So they were not repaid to me from the company.
What loan account is that?
My loan account with Neo Solutions.
Which bank account is that bank account?
It's not a bank account. It's a journal entry. It's a general ledger item.
Right. So, sorry, I'm confused because we'll go to it now, but there's a particular entry on the bank statements of Neo Solutions that you've identified previously in your affidavits before this commission and in your 204 statement relating to this transaction. So forgive me if I was focusing on bank statements. Let me just make sure that I understand your evidence. So your evidence is that you personally have never been repaid that money, correct?
Correct?
It's never come into your personal bank account with Nedbank, correct?
No.
Thank you. If we can then go to that line item that I was referring to in bank statements that you've previously provided, and you'll find that at page 14 of the same bundle that we're working in.
Page 14.
Now, Mr. Natterson, I'd just like to orientate you as to what this document is. It's a document that you initially supplied when you produced your Section 204 statement, and which you've subsequently provided to the Commission again as an annexure to your 12 July statement. Now, the way that this is described, we need to go back into your statement just to understand. So if we could do that, you go back a few pages, and you'll find that at page 7 of the same bundle. That's DD10A.
I think the 300,000 is brought up twice. But yeah, on paragraph 6.
I'm at paragraph 6, where you say, Van Wyk requested that an amount of 300,000 needs to be paid to him in cash, and this amount was paid to him on 4 January 2016. Do you see that?
Correct?
And then there is a further indication over the page at 11, where you say Van Wyk also requested a portion of funds in cash, i.e. an amount of 300,000 given to him in cash on 4 January 2016,
yes.
Right? And then as I understand the statement, what's attached to it is then the bank statements reflecting that and the other amounts. Is that correct?
Yes.
So let's go to page 13, if we may.
Yes.
At page 13, those are the bank statements showing the monies coming into Coroneka, correct?
Money is coming into
Sorry,
Nedbank
from Coroneka into the Neo Solutions Nedbank account,
That's
correct?
Right.
And then if you go over the page, that is what you flag as the entry in the bank account on the 4th of January 2016 related to the 300,000 cash that was paid to Mr. Van Wyk, correct?
Correct.
Mr. Natterson, when you testified last time, you said that that entry indicates a transfer from the Neo Solutions Nedbank account to the Neo Solutions Standard Bank account. Is that correct?
That's correct.
Why was it then identified as the entry on the bank statements of Neo Solutions that related to the 300,000?
My understanding is the accountant at the time processed that transfer to reflect then that he did the journal entry, or ought to have done at the time, the journal entry in the books to show that it goes against my loan account, but this was effectively accounting for the fact that this money is no longer part of Van Wyk's monies.
I'd just like to leave, if we may, accounting matters aside from bank
But that's my
statements and
understanding.
monies, certainly. I understand your evidence to be you used your own personal funds to give 300,000 Rand in cash to Mr. Van Wyk, correct?
Yes?
And no suspicions were raised for you when he called you on the 4th of January and asked for cash to buy a car. Is that correct?
That's correct.
And you didn't probe with him why he didn't go and get it from the bank?
Well, I understood it to be short notice that he wanted to conclude the sale on the vehicle.
Why would that make a journey to the bank unavailable to him?
I don't know how long it takes to secure 300,000 cash from a bank on short notice.
Did you ask him?
I didn't.
Did you say to him you'd the previous month given him 7 million of the 9.9 that he deposited with your company in November, and so why doesn't he use some of that money?
I didn't ask, but remember, I understood that to be related to property.
And then, when you depose to your 204 statement, and when you give your affidavits to this commission, you highlight this transaction in the bank statement of Neo Solutions on the 4th of January as being related to the 300,000 in cash that you gave Mr. Van Wyk, correct?
Yes?
But this entry has nothing to do with you personally or Mr. Van Wyk, does it?
My understanding is when Udeel, who helped prepare the statement, went and sat with the accountant had explained to him that this was to give effect to record on his side that the funds were no longer they were coming off Van Wyk's amount on the net bank account, and he accounted for them in the Standard Bank account as then part of Neo Solutions money.
Mr. Natterson, is this statement Mr. Udeel's statement or your statement?
The statement, Mr. Udeel assisted me in preparing the statement when we gave him the facts, and he also interrogated the accountant at the time.
But did you check what was being said in the statement and attach to the statement before you deposed to it?
Yes, when I sat down, I understood this to be the nature of why it was reflected here, to give effect to the fact that this money had come off the loan account.
But why didn't you say, but this is not a payment to me, and it was me who gave him 300,000 rand in cash, so I must look for some entry that reflects that 300,000 rand?
Because this to me was to reflect that it's now come out against my shareholder loan account, and therefore it's accounted for correctly in reconciling to the full 9.9.
Mr. Natterson, you'll accept, though, that it's simply a transfer between one Neo Solutions bank account to another Neo Solutions bank account, correct?
That's been my testimony already.
Thank you. Mr. Natterson, you also indicated that you made no inquiries of Mr. Van Wyk afterwards about the actual vintage car that he urgently needed monies for. Is that right?
I didn't.
And do you have any knowledge of whether he did buy a car around that time?
I testified that I didn't have any.
Apologies if I missed that. So you just had no follow-up with him about whether the urgent 300,000 was actually used to buy the car?
I was still away on holiday, so I think a week or two had transpired when I got back, and then obviously I didn't think anything of it since.
Did you continue to have interactions with him after that point?
Yes, he was still obviously on the farming venture. There was still interaction happening.
So at no point you asked him whether he concluded the sale that he urgently needed the monies for?
I can't recall if we did or didn't discuss it afterwards.
So would it surprise you to learn that he made no purchase of any vintage car around that period?
I can't speculate on that.
No, I'm asking, would it surprise you if you were now told Mr. Van Wyk made no purchase of any vintage car around that time?
Well, given what we know now of what's happened, obviously it doesn't surprise me. But at that point in time, I know he had a collection of cars, and he had shown me pictures. So based on it, I assumed he would have bought one.
So do you now accept that he was asking for the 300,000 rand for something other than a purchase of a vintage car?
I can't speculate on that.
Well, I understood your evidence to be, now knowing everything we know, you wouldn't be surprised that he hadn't purchased a car. What does that mean?
Well, if the funds were used for something else, then I do not know what they were used for.
But it wouldn't surprise you that they were used for something other than what he told you they were going to be used for.
I've answered that already.
What was the answer? Just
that it
remind
wouldn't surprise me now.
Thank you. Mr. Natterson, just to conclude on this aspect then, I'd like your comment on these aspects of your evidence. It's clear that you paid Mr. Van Wyk 300,000 rand in cash from your personal funds, correct?
I've said that already.
And you thereby enabled him to convert a portion of the money that had been paid into the Neo Solutions bank account into cash, correct?
Thereby enabled, please clarify.
Okay, so remember what happened was the business of Coroneka, through an electronic funds transfer that is tracked through the banking system, paid 9.9 million into Neo Solutions bank account, correct?
Yes.
There is no electronic transfer record of the 300,000 Rand cash that you gave to Mr. Van Wyk or facilitated being given to him on the 4th of January 2016, correct?
Yes.
The consequence of that is that funds that are tracked in the electronic banking system were converted to cash in a way that won't be reflected on that system, correct?
Correct.
So it wouldn't be reflected as a payment out of Neo Solutions directly to Mr. Van Wyk, correct?
Correct.
And it wouldn't be reflected in Mr. Van Wyk's own bank account if he'd gone to a bank and actually withdrawn the 300,000.
Correct.
That's what I mean when I say convert. Monies that came into the account in a particular way that can be tracked by an electronic banking system into cash.
Correct. And that was the basis of the creation of the 204. The Section 204 affidavit was because of the cash flow.
Indeed. And you identified a transaction on the 4th of January 2016 for this cash payment that had nothing to do with the cash that you gave Mr. Van Wyk, correct?
Explain.
I'm sorry, did you ask her, did you give an answer or you asked her to
No,
repeat?
I'm trying to understand.
Oh, okay, I think please repeat your question.
Indeed. You'll recall that the line item on the Neo Solutions bank account, bank statements, that you identified in your 204 statement as related to the 300,000 Rand cash that was given to Mr. Van Wyk on 4 January 2016,
Yes.
is the entry we saw at page 14,
That's
correct?
yes.
Do you accept that that bank entry is not reflective of the cash that you gave Mr. Van Wyk on that day?
I've explained that my accountant processed that transfer to show that that was no longer part of Van Wyk's money, and it then became my money through my loan account in the company.
Mr. Natterson, can we leave loan accounts from bank statements?
I don't think you can.
Well-
I think they are inextricably linked into
Right.
the transaction.
Explain to me how that is, because as I understand what's happening as a matter of banking, is Neo Solutions has two bank accounts, is that right?
That's right.
And one is with Standard Bank and one is with Nedbank, is that correct?
That's correct.
So what happens on the 4th of January, according to this banking entry, is that money is taken from the Nedbank Neo Solutions account to the Standard Bank Neo Solutions account, correct?
That's right.
That has nothing to do with cash that your brother went and collected at your house on the 4th of January and gave to Mr. Van Wyk.
No, I've clarified this already. The Neo Solutions Standard Bank account is our normal transacting account. When we engaged with Nedbank, the intention was to move our banking across to Nedbank over time. However, our day-to-day transacting, and you would have seen it from our bank statements, happens in our Standard Bank account. So the transfer that our accountant at the time did was to reflect that these funds were no longer Van Wyk's monies that were sitting in the Nedbank account at that time, which hadn't had much other accounting activity, which you can see on the statement. So it was placed there because the intention over time was to move across. However, the moment he moved these 300,000 across, it was his way of reflecting that these funds now belong to, via me, into Neo Solutions. That was the way he processed the transaction. So you cannot say that, yes, I understand from your perspective, I had given him cash personally, right? However, the way it's recorded here was to take it off in the way he accounted for it, take it off the loan account that Brian had into the use by Neo or be repaid to me at some point in time.
And it wasn't repaid to you?
I, to date, have not drawn that money out.
So it sits in the Standard Bank account. And did you instruct your accountant to identify this as the entry reflective
No, I
of...
didn't. It was the way he processed it for his understanding.
But why did you regard it then as the entry that would identify for Section 204 purposes the transaction?
When he had explained it to Udil, remember, I had first briefed you. When Udil came to me, I had then explained to him how this thing had transpired. He went and got the accounting information from the accountant, and then we sat together and we went through the affidavit. When I explained to him this is how it's happened, he said include it.
Who said include it?
Udil. on your deal.
So you were taking his advice as to which item to identify as related
He
to
had
this?
everything, and then his advice was include this in, so that you can then reconcile in total to the understanding of the 9.9 million.
In January 2016, Mr. Natterson, did Neo Solutions have an overdraft facility on its Standard Bank account?
Yes?
Are you sure about that?
I think you've subpoenaed that information. I think we did at that point in time.
Well, we can go to it in due course because that is not our understanding. That our understanding is that there was no overdraft facility available in Standard Bank at the time. There was an overdraft facility available in Nedbank. Is that
I
correct?
think that's correct, yeah.
I'm sorry. That answer, when you say that's correct,
The Nedbank facility was
yeah,
definitely correct.
but does it mean
Standard
that,
Bank, I can't recall when we had shut down, when we were in the process of migration across.
yes, no, what I want to understand is whether that answer now means that the two of you agree that there was no overdraft at Standard Bank, but there was at Nedbank.
Okay,
That's the position.
okay, taken.
No, I'm asking whether that's what your answer
I can't
means.
recall the exact date that we moved facilities between the two banks. I was aware there was a Nedbank facility.
Yes.
I'm not sure when the Standard Bank facility didn't or ceased to exist at that point.
At some stage, there was an overdraft facility
At
at the
Standard
Standard
Bank,
Bank account, but you can't remember when it was.
Correct.
Okay.
Let me assist you then, if I may. You'll find the email in which you move across to Nedbank in Exhibit DD10B. So we'll move to the other file now, Chair, if we may, and Mr. Natterson.
Is that DD10B?
B. And you'll pick up this communication with Standard Bank from Neo Solutions at page 442.131.
442.131.
Chair. Ms. Natterson, do you see the email at the bottom of that page? Apologies, I see.
Yes?
That is an email as I have it. Can you tell us who it's from and to?
So it's from Standard Bank, Pamela Lamprecht.
No, apologies, the one in the second half of the page.
Okay. From Jerome Jones, who's part of my accounting department, to Isaac at Standard Bank.
And the date of that?
That's 28th of July, 2015.
And can you read for us, just clarify, were you copied on that email?
Yes.
And just indicate to us what has been communicated there by Mr. Jones to Standard Bank.
That we will move our business to another bank with effect from tomorrow, 29 July 2015.
So does that give you the satisfaction you need to indicate to the Chair that you and I are agreed that by the time of the transaction in January 2016, you did not have an overdraft facility at Standard Bank, but you did have an overdraft facility at Nedbank?
At Nedbank, correct.
Thank you. Thank you, Ms. Nassen. I'd now like to move to an aspect of your testimony last time, which had to be conducted at the level of a hypothetical. You might recall that because at the time we were dealing with your financial statements ending February 2016, and we were dealing with your evidence at the page of those financial statements where cash and cash equivalents in the business were reflected. Do you recall that?
Yes.
And when we looked at that number, you said something appears wrong about it. Do you recall that?
I said yes, it doesn't reflect the facilities on the overdraft.
Indeed. And just in fairness to you, let's get that page, Mr. Natterson. You'll find it at page 210, if my memory serves.
Are we back to,
Of DD 10A, Chair.
Yes.
Unfortunately, we're back there. Apologies. And it was page 207.
207?
Yes. You'll recall there, as I recall your testimony, we looked down at the bank overdraft line item, which was at the bottom of the page, and that's when you said you thought that there was an error. Is that correct?
Yes.
And then what we did was we had a hypothetical engagement about if we could get the bank statements and if they could tell us what the position was at the end of February 2016, and if they showed that there wasn't an amount of 2.6 million available to repay Mr. van Wyk at that point, then it was the case that Neo Solutions had made use of the funds that Mr. van Wyk had deposited with the company, correct?
Hypothetically, yes.
Indeed. And your answer, in fairness to you in the transcript, at page 170, line 12, is you said, yes, in theory, correct? Mr. Natterson,
Hang on. Remember to just articulate your answer so
yes.
the
Instead of
recording will,
nodding.
yeah, because
Thank
when
you,
you
Chair.
nod, it doesn't get
The answer
captured.
is yes.
Yeah, okay.
So, Mr. Natterson, since your last testimony, we have been able to establish what the position was in relation to the two bank accounts of Neo Solutions at the end of February 2016. I can take you to those documents. They actually were attached to a second affidavit that your erstwhile accountant provided to the Commission, which you have been provided with. Let's go to those two bank statements, if we may. You'll find them in this DD10A bundle, and you'll find them at page 238.200, 200.
$238? Sorry, repeat that.
Point 200, 200.
238.200.
Yes, Chair.
Okay.
Mr. Natterson, this is the record that Mr. Patel indicates he used in order to establish the cash position of the business at the end of February 2016. And what is relevant is the fifth line down there, because that is the balance in the account. If you look at the date column, Chair, which is the second from the end on the right-hand side, if you go down to the fifth item, that's the last reflected balance on the date of 2016-02-29, which I understand to be the 29th of February 2016. Is that as you understand it, Mr.
Yes.
Natterson?
Yes.
And will you tell us what the balance there is in the Standard Bank account?
Okay, this one has been highlighted quite a bit over. I think it's 384,188.22.
Right, so about 380,000 was sitting in the Standard Bank account, correct?
Okay.
And then if you go over the page in the same bundle, that's the position in the Ned Bank account of Neo Solutions as I have it at the end of February 2016. And you'll find that as the last line item on that page, correct?
Okay.
And what is the balance on that date?
Minus 4632.328.23.
Right. And just to remind ourselves, There's no overdraft facility in the Standard Bank account at this time, correct?
I'm assuming so because of that email.
Yes, that was your testimony. So
There was
you
a
have,
point that the Standard Bank facilities were reinstated, but I'm not sure when that was.
right, but as at February 2016, there's only cash available of 384,000, correct?
On the Standard Bank account
Yes.
balance, but I'm not sure if there's an overdraft facility.
No, we
against
just
it.
clarified that in your evidence.
Remember, we had terminated and moved across, but Standard Bank then won our business back. And we were in the process then of migrating back, hence the March movements, where the transacting happened from Standard Bank. So I'm not sure of what those dates are, but I know a Standard Bank overdraft facility was then reinstated at some point, but I don't know the date of that here.
If we get some information from Standard Bank and they indicate it wasn't available in February 2016.
Yeah, then I'll concede that, but I'm not sure when. As I'm saying, I'm not sure when it was reinstated.
If
But
there
I know
wasn't an
it would have
overdraft,
been thereabouts on that time because the transacting started to happen from Standard Bank from March, the next period onward, literally a month after this.
Right.
So I'm not sure what the date is, Chair, of when the facility was reinstated with Standard Bank.
if the facility was not reinstated on the 29th of February 2016, then the only cash you have available to you with Standard Bank is 384,000, correct?
Yes, if that's the case, yes.
And in Nedbank, what was your overdraft facility
At 5
in
million.
February 2016?
At 5 million.
So you had used up 4.6 million of that amount by the end of February 2016, correct?
Correct.
So the remaining available would be about 400,000 or a bit less, because that's 4.632 million, correct?
Yes.
So it's in the order of about 370,000 would have been available in the Nedbank account, correct?
Yes.
So as at February 2016, you did not have 2.9 million rands available to repay Mr. Van Wyk, correct?
If he placed a demand on us at that point in time, yes. But our ability with the banks is obviously to request temporary facilities whenever we have project demand. So we do that as a matter of course all the time. So had he come through and requested funds on short notice, we would have made an application and got an extension against it.
So the thing we're interested in at the moment, Mr. Natson, is whether Neo Solutions, the company, made use of the 9.9 million that was deposited with it in November 2016. And what I want to put to you have established with these two bank statements is that by the end of February 2016, you had used as a business the bulk of the 9.9 million, because available to you at that stage as a level of cash was 300,000 sitting in the Standard Bank account and about 370,000 sitting in the Nedbank account. Do you agree with that?
We did not make use of the 9.9 million because his funds were returned to him a month later. The bulk of the funds were returned to him. So as at the year-end balance, there was an amount of 2.6 million that still needed to have been returned to him.
No,
So,
but
as I said already, if he had approached us to request those funds back, I would have been able to obviously adjust my facilities and return his money.
Ms. Natson, I accept what you've said. I want to know whether the monies were used to fund the cash flow of Neo Solutions between November of 2015 and the 29th of February 2016. That's really what I'm interested
The
in.
funds were not in a ring-fenced account, so by
Correct.
very nature, they are part of our operations. So as I said, if he had approached us to say, can I have my money back tomorrow, we would have been able to return these monies by adjusting our facilities accordingly.
So they were used to fund the cash flow of the business
No,
between
I'm not
November
saying that.
2015?
They were inside our operational cash flow of the business because they were not in a ring-fenced bank account.
Explain to me the difference. The funds are being...
You're trying to imply, with due respect, you're trying to imply that I used his money to run my business,
Yes.
right? That is
Yes.
not the case. The funds were sitting in our operational bank accounts. As I said, I always understood that to be his money. So if he ever approached me to return his money, it would have been returned. It was not a decision where we would use his money to keep Neo or as a company alive. That was not there. And I don't appreciate you trying to insinuate that.
Mr. Natson, just trying to understand the position of your business between
Understanding is
November
great. I appreciate
2015
understanding. But to imply that we manipulated the situation to utilize that cash flow, it's not correct.
Ms. Hofmeyer will deal with the question the way she decides to deal with it. But I think what both of you accept is that at a certain time there was less money in the bank account than should have been there if, in order to meet any request from Mr. Van Wyk for that payment without having to make other arrangements with the bank. I think both of you accept that.
Yes.
Yeah, that at a certain time there wasn't enough money in the account.
Our limits are flexible.
Yes.
Chair, we are a projects business. So if I land a large project, I sit with the bank and I adjust my limits accordingly to be able to service a project. So
Yes.
if there's any change in my facility requirements, I sit with the bank. If we set a facility, let's say at 10 million, then the banks about 4 or 5 years ago introduced a charge for unutilized portions of overdraft limits. So we have a policy that we sit with them and we work out the limits at each point in time.
Yeah, no,
Right,
no.
so had Van Wyk approached me to say,
Yes.
I do require my money now,
Yes.
I would have then gone to the bank and say, can I adjust my limit accordingly so
Yes.
that I don't pay that fee for the unutilized portions?
Yes, no, I understand that, and I think Ms. Hofmeyer also understands that. As I understand the position, both of you accept that at a certain time, the amount that was in the bank account would not have been enough to repay Mr. Van Wyk
At that current limit
without
setting.
you having to make
Correct.
arrangements with the bank.
Correct.
That both of you accept that. Both of you also accept, don't you, that the money in the account had been used for the business for the business. You both accept that, is that right?
They sat within the operational account.
Yes,
So
whatever money, and what you are saying is you didn't put Mr. Van Wyk's money aside. It was mixed up, so to speak, with
Correct.
with,
We just
with
kept a
your
reconciliation
companies.
account.
Yes. And that mixed up money, if you know what I understand, was used for operations of the business. But I think what you want to say is, in using the money in the account, you didn't have in mind that I'm now using Van Wyk's money. What you are saying is, you knew that there is money that may have to be refunded to
all placed
Van
into
Wyk.
the farming venture.
And you took comfort in the knowledge that you could go to the bank anytime, and if he needed his money, and then be able to pay him.
Correct.
Yeah. But what I think you are not denying is that the mixed money was used for the operations of the business.
Yeah, they sat in the
Yeah.
operational account, so yes.
Okay. I don't know if that has helped.
It has indeed, Chair. I'm
Yes.
indebted.
Okay.
Ms. Nathan, why didn't you put it in a separate account if you wanted to identify it as not associated with the business of Neo Solutions?
The understanding at the time was that the funds were going to go quite quickly to the farming venture. So no separate money market account was set up for that. The intention was it wasn't going to last that long in the account. And
So-
obviously the venture took longer than planned and he had drawn out by then. So it just became a comedy of errors of not achieving that.
Right, so it was contemplated in the arrangement with him that it could be placed in the operational account of the business and would be utilized by the business in the interim. And as and when he needed it repaid, you'd make arrangements for that.
Well, the intention was to put it to farming, the farming venture or the business venture. When he started to collect or to retrieve money back to himself, that then changed that scenario. But it was not an agreement that it would be used in Neo's operation. It was neither discussed nor agreed, it just happened.
But wouldn't you have wanted to ensure that it was kept separate unless it was going to be utilized by the business?
We had a reconciliation running. Either way was fine. It was not the intention to utilize it by the business. It was that we would take it, we would then go into the business together, it would transfer across. And that timing was not expected to be any long period of time at the time when we started this.
As a matter of fact, though, you didn't take steps to ensure that it wasn't used by the business, correct?
No, as I said, it wasn't contemplated.
What was not contemplated?
That it was going to be there for any long period of time.
Thank you. Ms. Nassen, I'd then like to go to the facility agreements that you had with Nedbank at the time, because that's the one that applied the 5 million overdraft facility. And you'll find that in Exhibit DD10B. Oh, Chair, I see we're just before the tea break. It is a topic with a new document. Maybe it makes sense to take the break now, and then we can find those documents over the break.
Okay, we'll take the tea adjournment and resume at 11:30. We adjourn.
All rise.
Okay, let's proceed.
Thank you, Chair. We were going to look at the overdraft facility agreement with NAO Solutions and Nedbank, and you'll find that in DD 10B at page 442.137.
Please repeat the page.
442.137.
442.137.
137.
Yes.
Mr. Natterson, can you explain what this document is?
It's the agreement for the overdraft facility with Nedbank.
And that is an agreement between which entities?
Neo Solutions
Mm-hmm.
and Nedbank.
And I see a date at the top of page 442.137. What is that date?
It's February 2015.
And if you go over to the end of that document, which you'll find at 442.142, is that your signature sort of a third of the way down the page and then in the middle of the page?
Yes.
So can you confirm that this was the overdraft facility agreement in place between NAO Solutions and Nedbank from February 2015?
Yes.
Thank you. And if you can tell us, consistent with your evidence previously, at clause 3 it indicates what the amount of the overdraft facility is. What is that reflected there?
It's 5 million.
Ms. Nass, can I suggest you bring the microphone just a bit closer so that for record purposes
Yeah, sure.
it's clear. So you indicated the overdraft facility was 5 million,
5
correct?
million.
Thank you. And then if we go over the page to point 138.
I'm sorry.
Apologies, Chair.
Oh, I've just seen it. I
Yes.
didn't see at the time the reference to 5 million, but I've just seen it.
Thank you, Chair. That's
Okay.
clause 3.1.1 for the record.
Yes.
And if we go over the page to 442.138, I'd like to look at the last clause on that page that reads other conditions. Can you read for us the other condition at clause 8.1?
Yes. It's full transactional banking. It's it's redacted, and then Neo Solutions moves the Nedbank within 90 days of acceptance of this offer.
So that seems to accord with your previous testimony. Is that correct? That you had to move your transactional banking facilities from Standard Bank to Nedbank in accordance with this agreement. Is that right?
That's correct.
And there was that email saying in July of 2015 that we looked at that we're moving it across. So
Correct.
did you comply with this requirement?
Well, over time, we were trying to comply, but moving or changing the bank details with most of our government clients was very difficult. So we were in constant email communications with Nedbank, explaining where there were problems, altering the information to change it to Nedbank.
Thank you. And then over the page at 442.139, you'll see there's a clause 11.1.2. Do you see that?
11.1.2, yes.
It's under a heading called undertakings, and if I may just read that clause to you, it says the borrowers hereby unconditionally and irrevocably undertake, and then if you pick it up at sub 2, to furnish Nedbank with the management accounts of the borrower and any security provider on a quarterly basis as soon as they become available, in any event within 30 days after the end of the period to which such management accounts relate. Do you see that?
I see that.
Did you comply with that requirement?
I think we were providing them instead with the project schedule, showing what projects we were busy with, what income's coming from the project, which they accepted instead of this.
And is there some amendment to this agreement to that effect?
No, it wasn't amended. I think we had submitted those, and whenever they requested information of what incoming cash flows they are, we had submitted that and they accepted that.
And did you do that on a quarterly basis? What was the arrangement?
It was a monthly basis that they would submit, that the accountants would submit that.
And would there be correspondence to that effect where they were satisfied that 11.1.2 was complied with albeit that management accounts were not provided?
I'm not sure. The accounting office would deal with the business banker, and they would either meet or discuss it, and they would share the schedule out.
Did they ever complain that you had not complied with this condition?
No, not that I'm aware of, to me.
Okay.
Thank you. Mr. Natterson, you'll recall that on your previous day of testimony, we had to work with the hypothetical about what the position was at the end of February, and thankfully today, with the assistance of the bank statements, we've been able to confirm what the actual position was, because you'd indicated in your testimony that there was an error in the financials that we were working for 2016 at the time, correct?
Yes.
Mr. Natterson, there was an objection at a point in that evidence from your legal representative as to what the relevance would be if there had been use made of the funds that were received by Neo Solutions from Mr. Van Wyk. Do you recall that?
Yes.
I'd like to, in conclusion on this aspect, explain to you that relevance. But before we do that, if we can just confirm with you, given everything that you now know about the circumstances under which Coroneka received the funds and then Mr. Van Wyk wanted to place them with Neo Solutions, is it your view as you sit here today that those funds were involved in unlawful activities prior to them coming to Neo Solutions?
Sitting here today, yes, but at that point in time,
No,
I wasn't
indeed.
aware.
I'm simply asking today, you do take that view.
Correct.
Indeed, you even, I think, took that view after some of this was disclosed to you by Mr. Dudeel. And that is why I have it, you had a conversation with Mr. Van Wyk that you endeavored to record at a point in the middle of 2018. Is that correct?
I didn't endeavor, I actually recorded it.
Apologies. You successfully recorded, indeed. But as I understood your evidence on that recording, it was because you were so concerned to have learned at that point about the unlawfulness of the activities that produced those funds, that you were in essence trying to get Mr. Van Wyk to confirm that you had no knowledge of that unlawfulness. Is that a fair summary?
The way it transpired was that when I became aware that the funds received from Coroneka were not, let's use the word kosher, I then cooperated with Dudeel and the authorities in order to provide all the information to show that we were unaware at the time, we were not complicit at the time, and we were inadvertently used by Van Wyk to move those monies through us. And that's the basis of how the 204 came about. There was no interaction with Van Wyk at the time. He then called me in May of 2018, and that's when I chose to record the call, and obviously through that, get him to admit that I was not aware that that was state money at the time.
I'd like to then go to the legislation bundle, which I dearly hope has been made available to you there, and that the chair has a copy which could be handed to him.
There's one with my transcripts.
Oh, sorry, it did come up in the break. I requested it. If we could just hand it to you.
Are we done with DD10?
We are. At the moment, we'll go to the provisions of the Prevention of Organised Crime Act. It's a piece of legislation we looked at last time, and you'll find the relevant page at 17.
And I think I have not been finished with it. Oh, you're still looking for it. Okay. So I forgot that he has got some there. But on the spine, it would be written legislation.
He's waiting for the page.
Oh, I don't know if she has mentioned the page.
The page is page 17, 17.
Thank you.
You'll see that this is a page within the copy of the Prevention of Organised Crime Act that's been placed in the legislation bundle. Chair, for the record, that begins at page 11, but what we are focusing on is the provision that appears at page 17.
Yes.
On the last occasion of your evidence, we looked both at Section 4, which dealt with money laundering, and we looked at Section 5, which dealt with assisting another to benefit from the proceeds of unlawful activity. What I'd like to look at today is Section 6, which deals with the acquisition, possession, or use of proceeds of unlawful activities. And what I'm interested in there is sub B. If I may just read that into the record and then deal with the questions. Mr. Natterson, that section provides that any person who uses property and who knows or ought reasonably to have known that it is or forms part of the proceeds of unlawful activities shall be guilty of an offence. Do you see that?
Yes.
So that indicates that use of any proceeds of unlawful activities which ought to have been known to be lawful activities will constitute an offence. Is that as you understand it?
It's as it's stated here.
Indeed. And then to round up in relation to my learned friend's concern last occasion, the reason for probing with you, in fairness to you, whether NAO Solutions had made any use of the funds that it received from Coroneka and Mr. Van Wyk relates directly to Section 6, because Section 6 says any person who uses the proceeds, which they know or ought reasonably to have known to be the proceeds of unlawful activities, will be guilty of an offence. Do you see that?
I understand the basis of you raising it.
Thank you. Mr. Natterson, I'd then like to go just for a moment to your 204 statement, because I must confess, we had received your affidavit, your 12 July affidavit, maybe 40 minutes before the evidence started last time on the 12th of July. And albeit that I'd been able to look at it very quickly, I've subsequently been able to look at it in a bit more detail in preparation for today. And so there are one or two aspects that I just need to pick up on in relation to that statement. You'll find it right at the beginning of Exhibit DD10A. Mr. Natterson, you gave evidence last time about how this statement came to be prepared and signed. Do you recall that?
Yes.
As I have your evidence, and we can find it in the transcript if it's relevant to do so, but I recall you as having said in your testimony that Mr. Udeel obtained the bank statements from your accounts team, and that he then prepared the draft. He came and sat with you, and then you said, we obviously read it, and I concurred with it, and that is the affidavit I deposed. You didn't add to on the transcript, but I'm sure that was intended. Is that, as I recall your evidence, correct?
That's correct.
So just tell me, where did you meet with Mr. Udeel when you went through this?
He had come through to our offices.
And are those the offices in Rivonia?
That's right.
And you then said that you knew that he was a private investigator, is that right?
Yes.
As I understand it, you had actually put Mr. Van Wyk onto Mr. Udeel at a point where he was inquiring about the services of a private investigator. Is that correct?
That's not correct. It was Villa, who was one of our employees at the time, who recommended Udeel.
So just tell me how that came up. How did Mr. Van Wyk engage with you or your business at all about a private investigator?
No, Villa Steinberg was one of the people working on the farming business case.
Sorry, and is that person, can I just have the name again?
Villa Steinberg.
Steinberg, is that person employed in NAO Solutions?
He was at the time.
At the time, thank you.
Specifically for the farming venture.
Right, and how does it come about?
So when Van Wyk said that he had an issue with his business partner and he was looking for a private investigator, then Steinberg, and my understanding is Steinberg had recommended Udeel.
So did you know that at the time of the recommendation?
I found out in passing, I'm not sure when they discussed it, but I found out in passing on about that time.
And did that precede when Mr. Udeel started to engage you about the Section 204 statement?
No, that was much earlier.
Okay, so there's already a relationship between Mr. Van Wyk and Mr. Udeel pursuant to somebody in your company putting them together, correct?
That's right.
And then at a later point, you engage with Mr. Udeel about the Section 204 statement, is that correct?
When he approached me in October
of 2017.
That's right.
Thank you. And do you recall having paid Mr. Udeel an amount in recompense for his work on drafting the affidavit?
I was aware that he was going to invoice for travel expenses to come through and obviously obtain the affidavit.
So was he paid?
I believe so. I mean, I can't say yes or no in here, but I'm assuming he was.
Well, just help me with that, because that was an indication that you gave to the Commission at one of your meetings with them. Is that right?
Yes, I said he was going to invoice for it. I'm not sure if you're asking me if he was paid. I can't.
You
I can't
haven't
say that yes or
confirmed
no
that.
here.
Right. Do you recall being asked for the confirmation of that payment?
Yes, I think so. You did ask in that session, or the Commission did.
Yes, there was also a subsequent email requiring you to provide it. Do you recall that?
Okay, I think it must be there.
And have you taken any steps to establish whether he was paid?
I haven't since, no.
But it wouldn't surprise you if he was, because that was the understanding of the arrangement.
That was the understanding. He did indicate he wanted to be settled for his travel and disbursements.
Thank you. Did that strike you as odd, that a statement that has to be prepared under the provisions of the Criminal Procedure Act could be the subject matter of a payment to someone who would prepare it for you?
It wasn't that he was being remunerated for the service. He was being reimbursed for his travel costs of going
So
back
it
and
was
forth.
simply confined to his travel
That
to
was my understanding.
Rivonia. Did he have to travel far?
My understanding, he resides in the West Rand, and obviously he was engaging between the DCPI in Rustenburg or Northwest Province and there. So the amount of, I think he indicated around 10,000 Rand for disbursements for traveling back and forth. It didn't look unreasonable.
Okay. 10,000 Rand for traveling back and forth. Did he do so quite a few times?
Well, I wasn't aware how many times, but obviously he had to engage with the accountants to obtain the data. So it would have been a few times that he would have to travel back and forth, Chair. As well as obviously head out to the Northwest, to Rustenburg. I believe they were based in Rustenburg.
And when you met with him on that day at your offices, can you just take us through it? I understood your evidence last time was that he'd prepared the draft. Is that correct?
That's correct.
And then I understood you to say you read through it and you satisfied yourself as to its contents. Is that correct?
Yes.
And then you said you deposed to it. Is that correct?
That's right.
How did you depose to it?
With his attorney, obviously, the last time. Remember the first time we had done the draft? And then when he came through to depose, then he had a person on hand. I can't recall the person's name. It'll be on the affidavit.
So he brought somebody with him for the purposes of having you depose to the affidavit. Is that right?
That's right.
And he was in your offices when you did so?
That's right.
And you don't recall the name of that person?
I don't, but it'll be the commissioner of the affidavit.
Okay, so let's go to the Commissioner of Oaths page, if we can. You'll find it at 11. Was it Johannes Martinez Haynes?
I'm assuming so, yeah.
Okay. Do you recall him being introduced to you?
No, he just commissioned it for me. I don't.
So
Yeah.
Ms. Udeel organised for a commissioner to come with him
That's right.
to your offices in Rivonia for the purposes of deposing to the
Correct,
affidavit.
yes.
And did you depose to it in the presence of Mr. Haynes?
Yes,
And signed accordingly, and then he signed, is that right?
that's right.
What I'm curious about in that regard at page 11, Mr. Natterson, is why then what the Commissioner of Oaths indicates there is that the statement was sworn before him. I'm reading from the third line of the Commissioner's indication there. And the deponent's signature was placed thereon in my presence at Krugersdorp on the 4th of October 2017.
That was at my offices.
So why would he have filled in Krugersdorp?
I think they had pre-filled that section, but it was done at my offices. I don't know. I actually didn't see that part. All I did was I signed, I passed it to him, and then he had filled his.
Why do you think they would have pre-filled in Krugersdorp if it was being signed in Rivonia?
I'm not sure. But I'm sure you can call him.
I'm sure we can. Thank you. And Mr. Natterson, in your evidence, you also indicated that at that meeting when you were finalizing all of this, Mr. Udeel
I'm sorry, Ms.
Yes.
Hofmeyer. I see that in the Commissioner's certificate, Mr. Natterson, that
Yeah.
is the same part where Ms. Hofmeyer was reading from. I see that the Commissioner of Oath says he is the one who took the statement. I certify that the above statement was taken by me. Is that factually correct?
No, it was Udil who prepared that statement.
Yes, he just administered the oath.
Yes.
Yes, okay.
It looks like a template that they've utilized for this.
Yeah, maybe normally just says that, or maybe didn't pay attention to that part. I don't know, I just picked it up that he says he's the one who took the
No,
statement.
it wasn't. I didn't take the statement with him. It was
Yes.
Udil who assisted me in
Okay.
preparing
But he was in your presence in Rivonia?
the deposition thereof.
Yes,
Yes.
yes. And then I recall from your evidence last time you said during that interaction, somebody was put on the line, an investigating officer. Is that correct?
That was the earlier interaction when he was explaining to me what had transpired. It wasn't when we finalized this.
Yes.
It was in an earlier stage that he put, I'm assuming, the investigating officer on the phone.
Why do you say you assume he put the investigating officer on the phone? Because
He
your
said
last
he's phoning-
testimony was that he put the investigating officer
Yeah,
on the phone.
well, I'm saying because I did not confirm it, anything past the point. So I'm obviously providing that clarity now to say that he told me he was putting the investigating officer on the phone, and he was obviously, he engaged with her. It wasn't on a speakerphone, and they were discussing that he was preparing an affidavit, well, obviously with me, and that he would be bringing it through.
So did you not hear the call with the investigating officer?
I heard him on the call. I heard it was a woman's voice, but I didn't get the exact words that was being said on the other side. I understood the gist of what he said on this side.
And what was he saying?
He was basically explaining that he had obtained all the information regarding what had come through to Neo Solutions, how it had moved on, and he was preparing an affidavit with me, which he would bring through.
Thank you. Mr. Natson, yesterday evening we provided your attorneys with a further affidavit, which we'd received literally moments before from the investigating officer assigned to this case. Have you seen that affidavit?
Yes, it came through last night.
Thank you. Let's go to it. It's in the other bundle, DD10A, and it's at page 238.287. Apologies. When I said the other bundle, I should have said
Yes.
the same bundle, Chair. That was my
Yes.
error. We're still in A, and it's 238.287.
.247,
287, Chair.
287.
It is right at the back of that file. That may assist in navigating.
I see that Mr. Natterson seems to find these pages much quicker than I do.
Maybe that he's been working on it more recently, Chair, than
It's the
any
first
of
time I
us.
just probably quicker
Yeah.
flipping pages.
Okay.
So we're now at 238.287, and that is a affidavit deposed to by Ms. Mokhosi. And if you see at paragraph 3, she was asked to confirm whether she had met or had any interactions with you, Mr. Natterson, in person or telephonically, and she said no. And she was asked whether anyone else from DPCI had been in contact with or met you, and there she says not from the Mahikeng DPCI. Do you see that?
Correct?
So Ms. Mokhosi has indicated she's not had any interactions with you. Do you see that?
Correct, but that's consistent with what I'm saying as well. I dealt with Mr. Udil.
Yes. And so you never engaged with her. I had understood last time that there was a speakerphone. Was that
No,
incorrect?
he had put her on the phone and I heard the conversation. Well, I assume, as I said, it was the investigating officer, but he did put someone on the phone and engaged about that he's securing the affidavit and he would be bringing it through to her.
Right.
All I knew it was a female voice on the other side.
Thank you. And Mr. Udil, did you engage with him again before you gave evidence here on the 12th of July?
Yes, we did. He supplied an affidavit as well.
Thank you. I'd like to go to that affidavit if we may. You'll find it in the same bundle, and it commences at page 238.145. Is that Mr. Udill's affidavit?
Yes,
Did you read it before you submitted it to the commission?
I'm aware of it, yes. And
Did you read it?
I understood the contents, yes.
Okay. If you go to 238.147, at paragraph 13 there, Mr. Udill describes his involvement in the Section 204 statement. Could you read to us what he says at paragraph 13?
He says in paragraph 13, it is my understanding that pursuant to my advices to Natterson regarding my investigations herein and the matter under CAS 4908-2017, Natterson prepared and submitted a statement in terms of Section 204 of the Criminal Procedure Act to the investigating officer.
So that seems to contradict your evidence,
I'm
Mr.
sorry,
Natterson.
I was trying to see where,
It's the last paragraph on 238.147.
Paragraph 13, Chair.
on
Page 238.147.
the last paragraph?
Yes.
Oh, okay.
Chair, if we can just read the relevant part again. This is Mr. Udill explaining his role in the Section 204 statement. And I'll read it again just for the record. It is my understanding that pursuant to my advices to Natterson regarding my investigations herein and the matter under CAS 49/08/2017, Natterson prepared and submitted a statement in terms of Section 204 of the Criminal Procedure Act to the investigating officer. Do you see that?
Yes.
That seems to be inconsistent with your evidence about his role, doesn't it?
I don't think it's inconsistent. He was the person who approached me. He assisted me in preparing it, and that's the document that went through. I'm assuming submitted to the investigating officer is a process, but I did not physically meet with the investigating officer, if that's what you're trying to imply.
No, I'm not implying anything, Mr. Natterson. I'm just looking at his words. He says, Natterson prepared. Let's stop there. So I understand your evidence quite repeatedly to be Mr.
Yes.
Udill prepared it, correct?
Yep.
So that is inconsistent, right?
I think, well, if you obviously going to summons Mr. Udill, you come and account for what he said. I can't.
No, indeed, I'm just
I'm
asking
sorry,
you.
Ms. Hofmeyer.
Yes.
Maybe it might not necessarily be inconsistent, because if, for example, you get your attorney to prepare something for you and you sign, somebody might say, you prepared, even though it's your attorney who prepared. So there may be room for that, yeah.
Chair, indeed, I'm indebted
but
to you.
you may see how you...
Indeed.
Yeah.
If I can follow that up. Mr. Natterson, I understood your evidence previously and today to place great emphasis on Mr. Udill's role in putting together that statement. Is that a fair reflection of your evidence?
Yes, he greatly assisted in putting it together.
He-
You see, I don't know what the content would be required for a 204, so he assisted me with that.
Indeed. And then on your version, he took it away and made it available to the authorities. Is that correct?
That's correct.
So all that I'm interested in here is that neither of those two things does he take responsibility for in this paragraph. Do you see? He says you prepared it and you submitted it,
But
correct?
like the chair said, it's semantic. I mean, there's quite often that the document is prepared by somebody else physically, but in the way it's worded here,
Yes.
I did not prepare it. And Mr. Udill can easily, I'm sure you can summons him to come and account on exactly how it went down.
And you also did not submit it?
I didn't physically submit it myself to the investigating officer. He did that.
There may be, what I said earlier on might apply much more easier with regard to preparation, but with regard to submission, if he submitted it on your behalf, one would expect him to make it clear that he was the one who submitted it, even if it was on your behalf, rather than say you submitted it. Do you want to say anything on that?
Point taken, Chair. I mean,
Yes.
obviously, he can come and actually
and
account for
testify,
why he said what he said.
But you certainly didn't submit it yourself,
I
and you say
definitely
he
did not submit
submitted
it myself.
it.
I've never met the investigating officer
Okay,
myself.
all right.
And that's consistent with what the investigating officer is saying.
Thank you. And then if we can go to your statement of the 12th of July, it's again in the same bundle, and you'll pick it up at page 238.67. Mr. Natterson, before we look at this part of the 12 July statement that you provided, do you recall that in the 204 statement you indicated that you were going to take steps to report the conduct under Section 34 of what's called PRECA? Do you recall that?
Yes.
You did say that. So when you deposed to it in October of 2017, you indicated you would take steps to report Mr. Van Wyk's conduct under that act, correct?
Yes.
Thank you. Now, at paragraph 30 on page 238.67, you say there, now this is the affidavit or the statement you provided on the 12th of July 2019. Can you read for us what you said there?
Which paragraph again?
Paragraph 30.
Prior to learning of the aforementioned criminal investigation from UDEAL, I was unaware of any issues relating to the transactions between Coroneka and Neo Solutions and Batsamai. Accordingly, upon learning of the criminal investigations and the alleged implication of Neo Solutions therein, I candidly and voluntarily disclosed the extent of my knowledge and the involvement of Neo Solutions in the alleged criminal activity to the Directorate for Priority Criminal Investigations, the DPCI, and further submitted a statement under oath in terms of Section 204 of the Criminal Procedure Act 56 of 1955.
So did you have any interactions yourself with the Directorate for Priority Criminal Investigations?
No, my understanding from, again, engaging with Mr. UDEAL was that there's already a case number in play, so there was no further requirement to disclose any further because the existing case number would apply over this matter.
Why then include in your Section 204 statement that you take steps to report it under Section 34?
It's UDEAL who had inserted that clause anyway, but when I mean, obviously from my previous testimony and my subsequent follow-up with UDEAL, his understanding was there's already a case number on this exact matter, and they wouldn't then be opening up another case file.
So did you specifically engage with him about the need to...
After I testified the last time, because I hadn't before then understood that I needed to do any further obligation. There was already... He had already said that was all that needed to have been done, that the matter was already with the Commercial Crimes Unit, and therefore there was nothing else to be done past that point. So although, yes, my 204 makes reference to those further steps, my understanding from UDEAL was that those steps were already in play.
I just would like to probe that a bit further, Ms. Natterson, because I'm not sure I understand it. I understand your evidence to be Ms. UDEAL prepared the draft, correct?
Yes.
So he included in the draft that you would take steps to report it under Section 34 of PRECA, correct?
That's right.
If he knew there was already a case number and no need to report it, why would he have included that in your statement?
I'm not sure why that's there. All I'm saying is then UDEAL himself can come and account for why that's there. All I've done is that when I asked him about it, is there anything else I need to do? He said he's engaged with the prosecutor, and there was no further steps to be taken by myself from it.
When did you ask him that?
That's straight after we prepared the affidavit. I asked him what else, and then again, when I took the recording, I called him again and I said, can I submit you the recording that I've got, which is further evidence to show that I was not aware that this was state money. And then he said, no, they've got all that they need, and there's nothing further for myself.
Thank you. Ms. Natterson, I'd then like to go to the evidence of Mr. Patel, who was your erstwhile accountant, if we may. Chair, Mr. Patel has provided two affidavits. He provided one just the day before Mr. Natterson testified the last time. Then there was a follow-up from the Commission in relation to that affidavit, and then he provided a second one. And both of those have been provided to Mr. Natterson.
Yes. Are they in the same bundle?
They're in the same bundle. Generally, Chair, the way it's arranged is when we're in affidavits, we're in Bundle A, and when we go to other documents, I'll take you to B. But for now, we're in A, which is the various affidavits. And you'll find the first affidavit at page 238.1. Mr. Natson, just to confirm for the record, you've previously been provided with both of these affidavits, correct?
Correct.
And you have yourself provided an affidavit in response, correct?
Correct.
That, according to my records, was sent through on Tuesday of this week, the 27th.
I'm not sure
we
when
can
the
go
lawyer
to,
sent it through, but I'm assuming yes.
I assume that'll be common cause. If we can then go to your affidavit, which was the response to this affidavit. You'll find it at page 238.264.
Three
is where it begins, Chair.
3. Oh.
263 is where it begins. Sorry, 238.263, Chair. I confuse my numbers from time to time. It's right towards the end. 238.263. Mr. Natson, just to orientate ourselves, apologies. This is the prior affidavit that you sent through to the Commission on the 8th of August. It's actually not the one responding to Mr. Patel. The one responding to Mr. Patel we'll come to just now. It's the next affidavit in the bundle. That's the one dated 27 August. But I would like to just look at this one for a moment, if we may. In this affidavit, if you turn over the page to 238.264, you say there at paragraph 6, well, let's start at 5, because you're providing some background in this affidavit. You say, on 12 July 2019, I was questioned at the Commission in respect of, inter alia, certain financial statements and or documents of NAO Solutions. Do you see that?
Yes.
And then at 6, you say, prior to such inquiry, I had alerted the Commission to the fact that the financial statements of NAO Solutions in respect of the financial year ending February 2017 were incomplete and or incorrect. Do you see that?
Yes.
Do you understand that, as I understand it, to mean prior to the 12th of July, when that inquiry took place, you alerted the Commission to the fact that the financial statements were incomplete or incorrect?
I'm assuming so, yeah.
Can you point me to where that was brought to the Commission's attention before you testified on the 12th of July?
I can't offhand.
So why would you have said that prior to the inquiry you did so?
I'm not sure. It's here, but obviously I'll have to go back into our records.
Because what is interesting is that you did depose to an affidavit the very day before, on the 11th, but you didn't in that affidavit draw the Commission's attention.
Okay.
So that would be incorrect then, what is stated at paragraph 6.
Okay.
Do you accept that?
Yeah, in the absence of seeing anything else, yes.
Thank you. And if we go to that affidavit, it's at 238.185.3.
That's quite something. 238.185.
185.3.
238.
0.185 is where we should possibly start, Chair,
Yeah.
because that's the filing sheet of the 11 July affidavit.
Okay, yes.
And then if you go over the page, it's an affidavit by yourself, Mr. Natson, is that correct?
Yes.
And it doesn't run particularly long. It's an affidavit that you provided to the Commission on the 11th of July. That was the day before you testified. Do you see that at the end of the affidavit at 238.185.5?
Yes?
And our records reflect that it came through to the Commission just after 5 o'clock on that day. Do you accept that?
I'm not contesting it.
Thank you. Mr. Natterson, this is where you deal with the production of documents. You'll pick it up at page 238.185.3. And they relate to the various documents that you'd been required to provide under a summons. Now, in this affidavit, I've read it quite carefully. You say nothing in it about the discrepancies in the financial statements. Do you accept that? And please feel free to remind yourself about its contents.
Yeah, there's nothing raised here.
Thank you. Now, despite it not appearing in this affidavit, as I understand your evidence, you had been alerted to the discrepancies in the 2017 financials
Yes.
already by the 11th. Is that right?
Yes, there was a meeting with the auditors on the 10th.
Okay, so just in time, you met on the 10th, which was the Wednesday of the week, as I have it, correct?
Yes?
And the auditors, of which Mr. Patel is the relevant responsible person, had indicated to you in that meeting that there were discrepancies in the 2017 financials. Do you recall that?
Yes?
And do you recall what the nature of the discrepancies were?
At that point, we didn't know the nature. It's just that there were several balance sheet items that didn't reconcile on the 2017 financials. So the way it transpired was that when the summons was received by the auditors, they contacted me. They asked for a copy of the financials or the management accounts that were sent through to the Commission, which our accounts department then sent through. Then they called a meeting to understand what had happened, and in the meeting, it was then established that Mr. Patel then informed me that there was the 2017 financials were different. There were discrepancies between the two versions, the version he had signed or authorized versus the version that we had on hand.
Yes, thank you for that, because that's my understanding of the nub of the discrepancies, right? It was that, and this is apparent from Mr. Patel's affidavit, we can go there if necessary, but could you just help me whether you understand his evidence in the same way as I do? So I understand Mr. Patel's evidence. He says he met with you on the 10th of July, and in that meeting he discovered that the version of the 2017 financials that had been provided to the Commission, with a covering page indicating he had signed off on them, were different to the ones he had actually signed off on.
Yes.
Is that your understanding of his
That's-
evidence?
Well, he had already received the copy that we had sent through to the Commission.
Indeed, that's the only way he
Yeah,
can do the
yeah.
comparison, right?
So it wasn't discovered in the meeting. He
No.
arrived at the meeting already having that
Yes.
knowledge.
So he asked you to send him the ones that were submitted to the Commission, which include a page from his firm indicating that they had compiled them,
Yes.
and which he signed off on. And then he goes back to his records and he discovers that the financial statements that he actually signed off on from 2017 differ from the ones that were submitted to the Commission. Is that correct?
That's correct, yes.
That is the nature of the discrepancy as I understand it, correct?
Prior to my testimony, yes. Yeah.
Yes, so this is indeed. And your testimony, just to be clear, last time, Mr. Natterson, only dealt with the 2016 financials.
Yeah, yeah.
Right, and we are only talking about a discrepancy that Mr. Patel identified with the 2017 financials, correct? Right. So that's the discrepancy, and he, I understand, is concerned about it, as you were, correct?
Correct, yes.
Because, as I understand his affidavit, it had been presented to the Commission that a set of financials that he signed off on were actually not the ones that he had signed off on and prepared, correct?
That's right.
Thank you. And then your evidence last time was that the next morning, so that's the 11th of July, Mr. Patel and his firm resigned as the auditors of NAO Solutions, correct?
Well, we received that notification via your office. They
That-
didn't send us correspondence resigning directly with us. It was actually notified via the attorneys.
Sorry, just explain that to me.
It was the correspondence via the attorneys that notified us of resignation. It wasn't directly to me.
From whom?
From Patel's attorneys to our attorneys.
Yes, sorry, so it didn't involve the commission.
Well, the affidavit was also submitted to you at the same
Sorry,
time.
but just to be clear, it was communicated to you through the attorneys of Mr. Patel and your attorneys that they were resigning as your auditors.
Correct, yes.
And that happened on the morning of the 11th of July, the Thursday, correct?
That's right, yes.
Thank you. And then I'd like to go to Mr. Patel's affidavit again, if we may. And you'll find that at 238.1. And if you go through, that is the start of Mr. Patel's affidavit, and then if you go to the end of his affidavit, you'll find it at page 238.5.
Did you say 0.5?
Yes, Chair.
Yeah.
That's the last page of Mr. Patel's affidavit, and I'd like to pick it up at paragraph 12 on that page. At paragraph 12, he says, on the morning of 11 July 2019, I received WhatsApp messages from Mr. Natterson, a screenshot of which is attached mark G, and the contents of which speak for themselves. Do you see that?
Yes.
And then if we turn over the page, well, it's a few pages we have to go to get to the WhatsApp message. You'll find that at 238.60.
238.60.
60, yes.
Okay.
Before we look at the WhatsApp message, Mr. Natterson, did you read Mr. Patel's affidavit as being concerned about the fact that NAO Solutions had submitted financial statements to the Commission purporting to have been signed off by him when they weren't signed off by him?
Yes, there were concerns because there's two sets of financials also signed off by me using my signature page as well. So it's concerning to both of us.
Indeed. And then he attaches the WhatsApp message and he says the contents of which speak for themselves. I'd like to go through that. My proposal is that we read the full WhatsApp message into the record. My proposal is that you read what you said and I read what Mr. Patel said.
Okay.
So can we go through it? It's at 238.60.
Okay. So I'm the one in white on the left. So.
Indeed.
Hi, please advise what is status. My attorneys want to prep correspondence.
And then Mr. Patel on the right-hand side, Chair, responds, hi, our attorney is dealing with the matter.
And I said, okay, are you just buying time or issuing correspondence of the difference? I just need to know how to prep.
And then Mr. Patel responds to say, we will revert back to you later.
Okay, then I said, Ranju, we've come a long way, really need your help here. We have to be able to reconcile this, else it will hurt all of us. Let's just work together on fixing this, please.
Thank you. And then, Mr. Natterson, you were invited by the Commission to respond to Mr. Patel's first affidavit and then on receipt of his second affidavit, that affidavit. And that, as I understand it, is what you took up in your affidavit provided on the 27th of August.
That's right.
So if we can go to that one, which is right towards the end of this file, Chair. And you'll find it at page 238.267.
That's not in my bundle.
238.267 is
It
not
goes
there.
from 266 to 274.
That's an oversight. Possibly we can just hand one up to you from my learned friend.
Yeah, sure.
Does Mr. Natterson not have that one?
It doesn't appear to have been placed in his file. It is his affidavit, though. So
Okay.
if I can beg leave just to hand up a duplicate so that we can
Okay.
work off it. Mr. Natterson, at page 238.267, you commence the affidavit, and then over the page at 268, I understand you in paragraph 5 to say you want to place the WhatsApp communication in context. Is that right?
That's correct.
Before we do the context, could we just pause a little on its actual wording? And for that purpose, Chair, I suggest that maybe we just take out the WhatsApp message where it appeared previously, and apologies for not asking you to do that at the time, that you'll find at 238.60. And then we can deal with the context once we've dealt with the words.
Yes, I've got it.
Thank you. So if we look at 238.60, which is the actual WhatsApp communication, it's early in the morning, as I see it, 9:48, and you're asking him for a status update. Is that a fair description?
Yes, there were several attempts to call him before then, though.
Which he was not answering.
Correct.
So then you endeavored to WhatsApp communicate with him.
That's right.
And you say you want a status update because your attorneys are prepping correspondence, correct?
That's right.
And his response says his attorney is dealing with it. Is that right?
That's right.
And then you say, okay, you just buying time or issuing correspondence of the difference. Just need to know how to prep. Why would he be buying time, Mr. Natterson?
So the context was that the initial summons to the auditors was apparently dispatched on the 28th, I think, of June, similar to a request from us, but it never arrived to them because they had moved premises apparently. So they received it on short notice. Just to also contextualize, the meeting that happened with the auditors happened with their attorneys present, and the second part of the meeting happened with our attorneys present. So when it came about in the meeting that there were discrepancies on the 2017 financials, then we then discussed we needed to identify what caused these differences, and if there was bad news that we had to correct the financials, then we had to do that jointly and approach the Commission directly with corrected financials. And the word buying time referred to them exercising the right to say they have time to prepare a response so that we could understand what caused these differences in the financials. And we had asked them to do that because we felt it would make both parties look very bad to come here with financials that are not aligned. So we were wanting to work together. They undertook, so when that meeting concluded, they undertook to give me the very resource that was working on our compilation engagement to actually come to the office and assist us in identifying the differences. And that's why I made so many calls to him that morning, was to send that resource through, so that we could understand what caused these differences and come and account. So if whichever, we at that point didn't know which version was correct as well from our perspective. So we said we needed to be able to come in and explain the differences, and that will restore credibility for both parties. And that was the context of these messages.
Why would there be any debate as to which the correct version was? Because it was clear which version had been signed off by Mr. Patel.
We were clear about that. However, Mr. Patel also said that he had relied heavily on the accountant preparing the information. And by that point in time, we were also then starting to become aware that the accountant on our side had also not prepared the information correctly. So Mr. Patel could have relied on incorrect data in terms of his compilation engagement as well. And that was discussed in the meeting. So at that point, it was, yes, it was the ones that he had signed off, but we also at that point of that meeting had known then that a lot of the information that was used to generate the financials may not have been correct.
Why would that have been a concern to Mr. Patel? He doesn't accept any responsibility for the documents he's provided by NAO Solutions.
Fair enough, but we wanted it right.
Yes. So why would he be wanting to buy time?
The buying time was to then exercise his rights to say, I've only received notice of the summons, which was given to him 2 days, or that very day of the 10th, is when he received the correspondence from the Commission asking him for that information, and therefore we felt that he could have sent a request back to say he needs time to be able to respond. That was the context of the buying time statement.
And it's an either or. You ask him, is he buying time or is he issuing correspondence of the difference?
With the difference,
Do you
because
see?
that was also discussed in the meeting. He, at that meeting when it closed, his attorney said they would consider what their version was, and they would come back to us as to whether they were going to request the extension or whether they would submit an affidavit explaining the difference.
And so that says you didn't know whether he was going to submit an
I
affidavit.
didn't know what path he was going to take.
Was it not fairly important to make known to the Commission that financial statements that had been prepared and presented to it were incorrect?
That was the intention. We were wanting to come to you jointly to explain that there were differences that we were not aware of in the financials that were on file. That was the intention. There was no intention to actually hide from that.
Right. So he would either buy time and not disclose that and take more time, or he would disclose it.
But to work with us in terms of identifying what caused these discrepancies, so we could come back to the Commission with one uniform response. That was the intention of that comment.
And then you say just need to know how to prep.
Yes.
Why would, whether he was buying time or bringing it to the Commission's attention that there was a difference between the financials he signed off on and those submitted to the Commission, influence your prep for your evidence?
Because obviously we would need a detail. If he was going to come up with the discrepancies, we would obviously need to be able to respond on our side. If it was that we would then jointly make a statement together that the financials are incorrect, and we're working together on reconciling it, and then we will come back to the Commission with a later date on the exact discrepancies and what caused them. That was what we were debating.
Either way, though, Mr. Natterson, I would suggest to you that it was incumbent upon NAO Solutions to make that clear to the Commission, wasn't it?
No, you understand, we also received it and we were arriving the next day. So our statement then obviously would have then had to cover that as well.
Yes.
We were aware that was...
But the statement you produced on the 11th of July didn't reflect the discrepancy at all, did it?
Well, we were still trying to obviously identify those discrepancies on our side. And we were still waiting for his resource to come in and assist.
Ms. Natterson, that's
until
why...
we got the notice of the termination.
Indeed. It's just why I spent a bit of time getting clear earlier what the discrepancy was. The discrepancy, as I understand it, when you met on the 10th, it was made known to you, was that NAO Solutions had submitted financial statements to this Commission purporting to have been signed off by Mr. Patel, which were not signed off by Mr. Patel.
That's right.
Why was it not incumbent upon you to make that known to the Commission as soon as possible?
Well, we wanted to identify what caused the discrepancies first so we can come with the solution and the problem at the same time. That was our intention.
So it wasn't enough just to say, hold on, Commission, you're dealing with financials purporting to have been signed off by the company's auditors that were not signed off by the company's auditors.
As I said, we had immediately started a process then to try and rebuild these differences ourselves. I wasn't aware that you were going to get to the financials during my testimony anyway, but it was our intention, obviously, to bring a response to you as soon as we had an idea ourselves as to what caused it.
Ms. Natterson, why do you say it wasn't clear that I would get to the financials in that testimony?
I mean, I didn't contemplate it at that point, but our intention was to be able to identify what caused the differences and then bring you a complete response around it. Not that we bring you, oh, there's a problem, hold, but we were going to bring it as one complete package.
And then later on, he says, back at page 238.60, we'll revert back to you later.
Yes.
And then you say, Ranju, we've come a long way, really need your help here. We have to be able to reconcile this. What had to be reconciled?
Reconcile in terms of the differences and the discrepancies between the two sets of financials. You'll see, he didn't actually supply you with the complete WhatsApp conversation, which is at the back of my affidavit.
Well, you can refer to
It's
where
at
it is.
238.273.
What page again?
238.273.
Okay.
Okay, so Chair,
Yes.
at that point we had established as well, at that meeting, we had established that the 2016 financials on our system in pastel had been overwritten by 2017 data. So at this point in time, I was still also trying to reconstruct that information within our records, and we had nothing to work from on our side. So my frantic, you can call it frantic messages to Ranju or to Mr. Patel, was to try and gain some assistance from him in terms of being able to reconstruct the data. So where it ends on his is, let's work together on fixing this, and you'll see straight after that I messaged him to say, have you guys got the 2016 trial balance? The TB, it refers to trial balance. And then I asked, was it 2017 that was with the discrepancy right? And then can we chat on the phone? I need to help her to understand where I stand with you guys. So that was, again, requesting the assistance for them to send the resource to come and help me identify the discrepancies that existed or that we had only found out the day before. So there was no intention to hide anything. It was to be able to make sure we maintain credibility, that when the moment we identified the discrepancies was to be able to identify what caused them and then bring them through to the Commission as one complete response saying, we're aware that we gave you this, we have detected this issue, and here's the corrected version, or here's reasons for the differences between the two sets. That was the intention of this.
Yes.
Ms. Nathan, why did you say to him, I'm back at page 238.60, we have been able to reconcile this, else it will hurt all of us?
It's damaging to both companies' reputations.
Ms. Nathan, as I understand Mr. Patel's version, he signed off on a set of financials, and when those same financials were provided to the State Capture Commission, different financials were placed under his accompanying letter. Why would that hurt Mr. Patel at all?
I think by very fact that any company or person that's mentioned coming to the Commission is automatically facing a reputational risk.
Not
Right.
if that person, if I may, is the person who brings to the attention of the Commission something that
No, fair enough.
is incorrect.
Fair enough, but there's also, you must also understand that the understanding that Mr. Patel has around his responsibilities for compilation and what he's saying in his affidavit is very different to my understanding. And when I say here that we've come a long way, Mr. Patel assisted me in a dispute resolution process with SARS, where him and his team were closely involved in resolving the disputes we had with SARS at that point in time in our 2010 to 2014 financials. So when I say I've come a long way here, he's aware of shortcomings in my own accounts department. So he's undertaking to me, when it comes to compilation of my financials, is far more, or the obligation he gave me for himself is far greater than what he's purporting it to be right now. So he had given me undertakings that he's the watchdog over my accounts department to ensure that the financials and the management accounts are correct when he prepares them, far beyond just what he's saying as his responsibility ended at purely compilation. He was aware of the process that we went through the ADR at SARS, and he assisted me greatly with that, and he had given me undertakings that he would be a better watchdog than a conventional compilation. That is the context of this item.
And off the back of his affidavit, he traversed none of that, did he?
Exactly.
All he said in his affidavit is, I signed off on a version, I've seen a different version presented to the State Capture Commission. That's concerning, I don't know how that happened. I'm bringing it to your attention, State Capture Commission, and I'm referring you to a WhatsApp communication which speaks for itself, correct?
Correct. And that's not the version that is there. We will cover it quite extensively under my re-examination.
Indeed. At this point, I'm just interested in what Mr. Patel said
Yeah.
to the Commission, correct? And then if we go into your affidavit again, if we may, which is a response to this, you'll find that at 238.268. That's where you start to engage in the context of the WhatsApp. Do you see that?
Yes.
And then you've actually traversed quite a bit of that already in your testimony, so I'd like to go over the page 238.269. And pick it up at paragraph 10. There you're talking about the tasks that you were going to undertake to try and sort out this accounting mess, for want of a better description. Can you just read into the record what you say at the beginning of paragraph 10 there?
On paragraph 10.
Yes, indeed.
I undertook the above task due to the fact that despite the fact that I can barely read that word. Sorry, the photocopy is quite bad here. I verily believe that Neo Solutions is not obliged to prepare audited financial statements as the sole director and shareholder of Neo Solutions. I felt that I had
No,
a
that's
duty-
fine. If we just stop at that sentence, if we may. You say that Neo Solutions is not obliged to prepare audited financial statements. Is that right? Understood from your testimony last time, you understand that because the Companies Act does not require it. Is that right?
Yes.
Was Neo Solutions ever under any legal obligation otherwise to provide audited financial statements?
Well, we're aware of now from the overdraft facility that there would have been a requirement to provide one day.
What do you mean we're aware now that the overdraft facility required it?
Well, I'm saying at that point in time, as a private company, I wasn't aware of the obligation under the overdraft facility, so that's probably why I'm making the statement here now.
When did you become aware?
Well, I've signed the overdraft facility document, but obviously in there I hadn't recalled that there was an obligation to produce financial statements to the bank.
So when did you become aware?
Now, well, when you now pointed it out to me now, I recall that it's the case.
So, Chair, it's probably not necessary to go there because Mr. Natterson confirms. But that overdraft facility agreement we were looking at earlier from Nedbank requires quarterly management accounts to be provided and audited financial statements to be provided within a period at the end of the financial year of the company. So, Mr. Natterson, I understand your evidence to be until you received that document a day ago from the Commission, you weren't aware that Neo Solutions had to provide audited financial statements to your bank?
All I'm saying is the requirement from the interaction with the banks was fairly relaxed in that we had been providing them with the cash flow schedule, and the banks, as long as the churn was being shown in the bank account, they didn't put pressure on us for anything else.
So your answer was generally speaking, related to the general position.
Correct.
That generally you didn't think there was an obligation.
Correct.
Okay.
Did Nedbank ever ask you for audited financial statements?
They may have asked the accounting team because the business banker used to interact with the accounting staff.
Would that not have been brought to your attention?
You must understand, Chair, that I'm very operational in the field. I live on the projects, and the team, between the accounting team and the outsourced to many financial services, the back office was being administered and looked after by them. I'm very operational on the projects themselves. So whether they raised it with me or not, I'm living out in the field, and generally they would attend to the stuff internally at the office.
Ms. Natterson, why then do you say that, as a positive fact, Neo Solutions had no obligation to provide audited financial statements?
I'm saying that as ordinarily as a private company, not needing it for anything else, that's our normal course of business.
So let me just clarify for our purposes. You weren't aware that the 5 million rand overdraft facility agreement you'd concluded with Nedbank in 2015 required your company to provide audited financial statements?
I was aware at the time of signing, but I was also aware that it was in normal flow. So all I'm saying is that I didn't recall it, I didn't treat it as a priority. The fact that the ongoing financial information was being sent to the bank and they were seeing churn in the account, it then dropped off everybody's radar screen.
Did your company produce audited financial statements in compliance with its obligation, which you've just testified you were aware of in 2015?
You mean that's the financials that Patel would have produced then, or the management accounts that they produced?
No, that's different to audited financial statements, is it not?
For 2015, we have not submitted anything to SARS yet. We're still busy with the process of, obviously, we had come through an ADR process with them, and then we were taking the opening balances from there into reconstructing the records after that. So the last official response of financial statements is the 2014 financials, that is the finalized dispute resolution process with SARS. And Patel was assisting us with all of those processes with SARS. It took a long time to conclude the ADR process with SARS, which was only concluded, I think, towards the end of 2017.
I thought earlier you'd said 2014.
2014 financials, but the ADR process on finalizing 2014's results was only concluded in end of 2017, maybe possibly 2018.
Ms. Natterson, you'll forgive me, I am just struggling to follow your version on this aspect. I understand your evidence to be you knew in 2015 when you signed your facilities agreement that audited financial statements were required, correct?
Yes.
Why did you say in an affidavit then that Neo Solutions is not obliged to prepare audited financial statements?
In the normal course of a small company under the Companies Act, we weren't.
Mr. Natterson, that's not what is said here. Do you
So
accept
fair enough,
that?
I will then concede it, that I hadn't recalled that there's an obligation under the overdraft facility agreement.
Yes, and you recalled it when the documents were sent to you 2 days ago, is that right?
Yes.
Mr. Natterson, you then at 269 continue to say that there was a controversy. This is at paragraph 11. You say, further, as a businessman, I was very concerned about the risk of reputational harm which could be suffered by Neo Solutions and Manny in such a situation, especially in light of the controversy which Neo Solutions is being involuntarily involved in by being associated with certain parties. Just help me there. What is that controversy?
I'm saying by very fact of being implicated with Van Wyk and the SA Express saga, that's what this is referring to.
And involuntarily, what does that mean there?
Because, well, we were unaware that the funds were state money at the time. So we wouldn't have participated in this had we known it was state money.
Thank you. And then if we go over the page, you are dealing there with your imploring of Mr. Patel to assist in reconciling. And you say there at 13, I implored Patel to attend to reconciling the financial documentation as well, to provide the relevant trial balances as a matter of urgency so that my aforementioned concerns would not materialize and hurt all of us. And also because I had no idea who else had seen such incorrect financial statements. Can I just stop there? Who else could have seen the incorrect financial statements?
I have no idea whether it was sent out to anyone else. Those incorrect financials were under the control of Ruben at our accounts department. So there was no instruction for me to distribute it with anyone else. So we've made a generic statement here that we're not sure of its distribution.
So would people in your employ be distributing the financial statements of Neo Solutions without you knowing?
I'm saying the fact that there were two different sets of financial statements, right? And we'll deal later with the fact that Mr. Ruben, we've now established that at least 740,000 Rand was misappropriated from the company directly to his own bank account. So would there be any reason for him to take create two sets of financials? Yes, maybe to distract from what he was doing. But if he circulated those incorrect financials somewhere else, I'm not sure of it. And that's what the statement is intended to
So it's got
cover.
nothing to do with Mr. Patel?
No.
Right.
But because his signature is on that document, it does have an implication to him, like with my signature.
Mr. Patel, as I have it, has no difficulty with the ones he signed off on, correct?
Yes, I understand what you're saying, but the fact is that there's an implication by it already being at the commission, so the context of this wording is exactly against that.
Just explain that.
The fact that now Manny's name is brought up at the commission, as is our name, then has a reputational impact. So we need to work together on resolving it. That was the context.
Thank you. And then you go on at paragraph 17 on that page to say, well, let me go a little bit higher. You say at 16, to confirm the aforementioned context, the full WhatsApp conversation between myself and Patel is attached, and we've looked at that previously. And then at 17, could you read to us what you say at 17?
I said the Commission's legal team is incorrect in improperly or prematurely claiming that my messages were intended to influence Mr. Patel to give false evidence to the Commission. In fact, there's no attempt by me of any such nature, and for the Commission's legal team to cast such aspersions is spurious.
Mr. Natterson, why do you say the legal team of the Commission is casting aspersions on you?
The insinuation that if obviously by reading just this without the full context, would appear, or you would try to create a case that I'm trying to influence Patel not to cooperate, which is not the case at all. All I said was we need to work together to get to the bottom of this and then come with a cohesive response so that we can clarify what caused these discrepancies.
Ms. Natterson, do you recall how you were asked or invited by the Commission to address Mr. Patel's affidavit in correspondence before you presented the affidavit yourself?
Yes.
Do you recall that the correspondence said that there were certain allegations in Mr. Patel's affidavit?
Yes.
And those were identified akin to a sort of Rule 3.3 process. You're familiar with that, I understand, because you've received a Rule 3.3 notice in relation to Ms. Tlatsana's evidence, correct? Yes. So it's allegations lying in the affidavit of the person that you're alerting about the fact of the affidavit. Do you accept that?
I don't understand the context of it, but okay,
let me explain.
Take your point through.
We can maybe go to the correspondence if that would help. It's at 442.34, and that's in bundle DD10B, Chair.
Page 442.
0.34.
Okay.
Chair, the letter begins at 442.32. Do you have it, Mr. Natterson?
Yes.
And it's a letter addressed to yourselves on the 15th of July 2019. Do you see that?
Yes.
That was the Monday after you testified on the Friday, wasn't it?
Yes.
So this letter, have you read this letter before?
Yes.
It's following up on aspects of the evidence as I have it. And then if you go over to 442.34, you'll see at paragraph 8 on that page, the Commission writes, finally, on 11 July 2019, you were provided with a copy of Mr. Patel's affidavit that had been provided to the Commission on even date. And it says, the affidavit makes the following allegations against Mr. Natterson. Do you see that?
Yes.
And then they're set out in paragraph 8.1 and then over the page at paragraph 8.2. Do you
Yes.
see that? Mr. Natterson, I just want to pause there because in your testimony just now you said the Commission is trying to make out a case, right? Do you accept that all that's being said here is that there's certain allegations against you in the affidavit of Mr. Patel?
Yes.
And do you accept that at the time this was put together, your further context was not available to the Commission?
Yes.
And do you accept that you were invited to respond to it?
Yes.
And when you took issue with this, you were again invited to respond to it and provide the context. Is that correct?
Yes.
So do you understand the circumstances in which paragraph 8 of this affidavit, and particularly over the page at paragraph 8.2, it was recorded that there is an allegation in Mr. Patel's affidavit that you, Mr. Natterson, had endeavoured to influence Mr. Patel to give false evidence to the Commission?
Yes.
Thank you.
I don't know whether you completed the point which I thought you were seeking to make, Ms. Hofmeyr. I understand Ms. Hofmeyr's last few questions in relation to this to be meant to suggest to you that the Commission's legal team might not have sought to make any allegations.
Yeah, I understand the context.
Yes,
It's
and
contained
you accept that.
I
they
understand
didn't.
that.
Yes, okay, all right.
So thank you, Chair, just to follow that up, because his affidavit continues to demand an immediate, unconditional and irrevocable withdrawal of the allegation.
Chair, I think we're going to deal with this as well under my re-examination, so
Yes,
there's
no, but
need to belabor it.
deal with it now, because the re-examination that will happen is intended to clarify what might not have been dealt with adequately. So it's better if you deal with it now,
Okay.
and then if there is something that your counsel wishes to clarify later on, he will do so.
Okay. Can you repeat the question?
Yes. So given your answer to the Chair, I take it that you don't any longer demand that the Commission's legal team immediately, unconditionally and irrevocably withdraw the allegations made?
I'm saying if there's a perception that we attempted to influence that is incorrect, there is the context that we've provided, and if that perception still exists that we attempted to influence, then we would obviously seek correction on that. And we
But-
will deal with that there.
Mr. Nathan, you accept it's not the legal team of the Commission's allegation, is it?
Yes, okay, I'll concede that for now, for moving on.
Thank you. Mr. Natterson, there was a matter, it's a brief matter before we break, and then, Chair, there's only one matter after the lunch break that I will deal with. But just before then,
Yes.
we dealt with a donation last time that appeared in your 2016
Are we back
financials.
to the other bundle?
No, we
Oh,
won't have to even go to the
oh,
bundle, Chair,
okay.
because it relates simply to the testimony of Mr. Natterson last time. We were looking at a donation entry in your 2016 financials. Do you recall that?
Yes?
And I asked whether you knew to whom that donation had been made. Do you recall?
Yes?
And then your testimony was you didn't recall, but then you and I agreed if we could get the accounting records that may be disclosed. Do you recall that?
Yes.
Mr. Natson, we've been indebted to you since that evidence to have provided us with those accounting records that you've managed to assemble.
Yeah, the partial portion, because
Indeed.
it's an ongoing process.
It's an
right
ongoing
now.
process. In fairness, it sounds as though the accounting
It's a shambles.
system in your business is in complete shambles. Is that fair?
We've technically been sabotaged.
Right.
The information has been totally removed from premises. They, obviously in an attempt to cover up the fraud. The nature of the fraud obviously was he had amended beneficiary details. So even where we had payments that appeared to be valid to suppliers, they actually have been altered bank accounts to be other bank accounts. And then the supporting documents are non-existent. So the reconstruction process is a long, hard haul for us right now. So whatever we've been able to put together has been forwarded across.
Thank you. I've found no documents there dealing with the donation. Did you come across anything?
When we attempted to establish what caused these donations, from what we can see, it's far less than that, but we are busy reconstructing the record. So I can't yet answer that. I know for a fact we've nowhere made anywhere close to those kinds of amounts as donations, but until I reconstruct the record, I cannot come back and say what that exact number was. It's definitely not 2 million though.
Right. So when you signed as the Director of NAO Solutions, those February 2016 financials, were you not aware that there was a overly exaggerated donation amount in it?
No, I didn't. As I said, I relied on the fact that Mr. Patel was checking these financials, and he was the watchdog over the process. So if it was put in there, I didn't even look at that number. I signed off.
You didn't look at that number or any other part of the financial statements when you signed off confirming their accuracy?
I would have cast my eye around the totals of the income, the net income, and then obviously looked at the balance sheet to see that it looked reasonable, and that was it. But without going into specifics of numbers.
Do you think that's a reasonable approach for a chartered accountant to take when signing off on the financials of his business?
I'm not operating as a chartered accountant in my business.
Ms. Nasson, I know that that's an aspect that you want to take up in relation to Mr. Lowenthal's affidavit, and we'll do that after the break. Do you accept that in your testimony on the last occasion, you accepted that you were a chartered accountant in business?
Yes, I did concede it then.
You now take a different view, correct?
I'm saying we will be guided by Mr. Lowenthal's affidavit when we go through that.
No, I'm just asking whether you now say that you're not a chartered accountant in business.
I'm saying the provisions relating to how a chartered accountant in business is measured in terms of his responsibilities to the company is related to what services he performs within that company. I'm not operating as a chartered accountant in my company.
So-
I'm technically a project manager.
So when you conceded that last time, it was in error.
It wasn't in error. It was being put on the spot at that point in time saying, yes, I am a chartered accountant. I am one in business. I wasn't aware of the specific obligations and provisions relating to that. I'm not operating in the accounts department of my own business. I've outsourced that activity to an internal accounting department as well as an external compilation engagement where they undertook to provide certain services to me. So I'm allowed to rely on those services in order to assume certain things, which I did at that point in time.
So basically what you are saying is, I am an accountant. I do have the knowledge that can reasonably be expected of an accountant, but in the business, I am not operating as an accountant. I've hired somebody else as an accountant to look after the business.
Yes, Chair, internally and externally.
Okay.
Thank you, Chair. And Ms. Natterson, when did you come to the realization that you're not a chartered accountant in business?
It was on the advice of the, straight after the last testimony, I appointed an independent chartered accountant to come in and obviously help me with the books, because it was also evident that the 2016 financials were incorrect from the interrogation at that point in time. And we subsequently established that the 2015 records were also incorrect. So there's a process of reconstruction that's been happening. And then in the mandate given to the independent accountant that we've appointed was also to guide me on the rights and obligations on a chartered accountant in business, and whether my understanding of my role is within the context of what Advocate Hoffmeyer had purported at that point in time.
Thank you. Chair, my proposal is, with your leave, to take the break now, and then we will move to Mr. Lowenthal's affidavit after the break.
Yes, no, that's fine. We'll take the lunch adjournment and we'll resume at 2 o'clock. We adjourn.
All rise.